insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to today's live webinar, brought to you by immigrationquestion.com, a networking platform and meeting ground where immigrants, professionals, employers, and licensed immigration attorneys come together to learn, exchange information, and stay current on US immigration developments. My name is Shelton Prince, and I'll be your host for today's session. Which US work visa is right for you? Choosing the right US work visa can feel overwhelming, with multiple visa categories, strictly eligibility standards, and evolving USCIS review practices. Selecting the wrong option can lead to unnecessary delays, denials, or missed opportunities. Understanding how different work visas function and how eligibility is evaluated is essential for anyone planning to work in the United States. To guide us through this critical discussion, we are joined by attorney Ibrahim Caglar. He is the New York-based immigration attorney who works with professionals, employers, and families across a wide range of employment-based immigration matters. His work focuses on careful case analysis, thoughtful preparation, and helping individuals understand how USCIS evaluates work visa filings in a competitive environment. Attorney Caglar, thank you so much for joining us today. It's always a pleasure to have you on the live stream.
Thank you for inviting me.
Before we begin, a quick note for everyone tuning in. Immigrationquestion.com is not a law firm. It is a networking platform created for education and discussion where licensed immigration attorneys participate independently. To everyone joining us from Facebook, YouTube, LinkedIn, and other platforms, welcome. If you have not subscribed yet, now is a great time to do so. So grab your notepads and let's get started. Attorney Caglar, when someone is deciding between work visa options such as H-1B, L-1, O-1, E-2, or TNs, what background factors should be evaluated first to avoid pursuing an unsuitable category?
Great. That's a great question. Before even naming a visa category, I always start with this questions, these core threshold factors, such as nationality, current location and status, employer structure, nature of the job, and long-term intent. So that's how these factors are very important. For example, nationality, because some visas are nationally restricted. For example, E2s. You have to be able to apply for an E2 visa, you have to be a national or citizen of an E2 treaty country. And this can immediately eliminate or prioritize options for you. And another thing that I look at is the current location and status. Is the person inside or outside the US? Are they in valid status? Are they subject to H-1B cap? So this is important too. Another thing that I look at is employer structure. Is there a U.S. company only, or if there or a foreign parent, or if the individual who's planning to apply for work visa is working for a foreign parent or affiliate, because this is very critical for for example L1 visas. That will it's a great option, I think. Or employer structure. When I say employer structure, I mean, like, is it a startup, or it's an established company, or is it a self-owned business? These questions are very critical when you're choosing, when you're deciding between the visa options that you just listed. And the nature of the job is very, very important too. One of the most important factors, I say, is that it's the nature of the job. Is specialty occupation versus executive managerial versus extraordinary ability, or trader and investor. So what kind of job you have, or what kind of job of the nature of the job that you are applying to, right? Job duties must fit the legal definition of the visa category, not just the job title. This is very important. The USCIS looks at this when they are adjudicating the visa applications. And the last thing I look at when deciding the work visas for applicants. We do this together, of course, with the client, is the long-term intent. What they are trying to achieve here. Are they trying to come here to gain experience and work here for a couple of years, or they have a goal of staying here permanently? In other words, are they trying to get a permanent residence, a green card in this country? So these are very, very important questions when deciding a work visa. And I say to my clients that you should look at all of them and try to answer every question to find the best option for you.
Thank you, Attorney Caglar. The question I've got here for you. So what are the most critical differences between short-term temporary work visas and options that may support longer-term employment goals in the United States?
Okay, great question again. Thank you. I think the most important distinction is the strategic intent, not the duration alone, right? I try to look at the visa options as, okay, non-immigrant focused and immigrant focused visas, right? They usually, you can also categorize them as as a short-term and long-term, but I believe that it's a better way to categorize the visa options as non-immigrant focus and immigrant focus. What I mean by that is, for example, like E2 visas, they are non-immigrant visa. They're one of the non-immigrant visas, and when you apply for an E2, it can be short-term, but it can also be a long-term too, because you can renew an E2 indefinitely as long as the company and as long as you qualify for an E2 and the petitioner, because an employer needs to petition for you if they qualify for E2 too. So it is, but you're not going to be able to get a green card or a non-immigrant visa based on that. But I want to talk about the distinction a little bit more. Meaning, like, okay, what is the difference then, right? The key differences. Okay, for a short term, and most of the time the non-immigrant visas, they are faster to obtain, more restrictive on job changes, and less flexible for self-employment. On the other hand, a long-term visas such as L1As or O1s with EB1 alignments. This one of the visa applications that we see a lot is that people apply for O1A and later they apply for EB1, which is a green card application. So their advantages are they have, for they are advantages in terms of getting a green card and staying in this country permanently. And it's more suitable for people who has a goal in mind, as I said in the beginning, like strategic intent to stay in this country. So that's what I say,
Okay. Makes sense.
Yeah.
Thank you, Ibrahim Caglar. And thank you for that. And the next question I've got you is, how does education level, professional experience, and the nature of the job offer influence how the USCIS evaluates eligibility across the different work visa categories?
Okay, that's a great question. So
Yeah.
it is, so when USCIS evaluating a visa application, right? They look at all the evidence, all the package, and they look at the alignment, not only the credentials in isolation. So what I mean by that, they look at education, they look at professional experience, they look at nature of the job offer, they look at the employer, all of it together. For example, when I say education, if you're applying for an H-1B, degree must be directly related to job duties. But if you're applying for a T1, degree must match the listed profession, not just be related. Or if you're applying to O1, degree alone is never sufficient. It is very important, but it is not sufficient. It's about distinction. So every visa type has, when USCIS is evaluating that, they look at the requirements and alignment and your education, your professional experience, nature of the job offer. When I say professional experience, for example, if you're applying to L1, experience must be qualifying employment abroad in a managerial, executive, or specialized role. So I can just go on and on the requirements of every type of the visa that we talked about. But what I'm trying to say in short is this: when they receive an application and work visa application, they look at the whole package, your education, experience, nature of the job, and if there is an employer, they look at the employer too.
Okay, interesting. Thank you, Tony Caglar. The next question that I've got you is, what are the most common mistakes you see applicants or employers make when choosing a work visa? And how do those missteps typically affect timelines or case progression?
Great. So, one of the most common mistakes, I think, is that that I see is that they choose the visa first. Like, for example, I want to apply for an H-1B. Instead of saying that, okay, do I qualify for an H-1B? Or the H-1B is the best option for me, right? So choosing the visa first and the facts second is never it's never the right approach.
Okay.
Or second most common mistakes I think I see is that generic job descriptions, copy paste duties or job descriptions, they trigger RFEs and denials.
Okay.
Underestimating companies' scrutiny, like especially for new companies, startups, small companies, or new offices for L1Bs, for L1As. It's just, you have to, if it is a new company, if it's a startup, you have to be more careful with your application. Ignoring future consequences. For example, filing a weak case that becomes a part of the permanent USCIS record for you or for the company. So every application you file with USCIS, you have to think about the future consequences, and you have to be careful with your application. And timing mistakes, it's maybe the most common one. Let's say you are here on a student visa or a visitor's visa, and your current status is expiring next week, right? You go to an attorney, I want to change my status. I want to apply for this. Hey, you're late. I know your status is expiring next week or 2 weeks from now, but you should come to my office at least a month before. Yes, because it will take time to find the right option for you and prepare your application. It will take time, so we want to make everything right. So that takes a little bit of time. Don't go to an attorney's office just 2 days before your expiration date. That's one of the most common mistakes I see. Actually,
so interesting. I suppose not good for any of the parties, right? So that's such valuable insight. Thank you, Ibrahim Caglar. So and I think the next question, I think, just building onto that, right? So like just based on so from a preparation standpoint, right? So like what documentation or planning steps should employers or applicants have in place before filing to reduce unnecessary delays or follow-up requests?
Okay. Good question. So for employers, I think they should have clear organizational chart and clear financial documentation, especially for startups, for small businesses, and job description tied to business operations are very important, and also evidence of supervision and control, depending on the work visa you're applying to or you are petitioning to. And for applicants, clean, consistent resume and work history. As I said for the previous question, is when you are filing a petition with USCIS, that becomes a part of the record. So every time you file an application, you should consider this. And then when you're filing a resume, should be clean, consistent resume and the work history, right? Degree evaluations, if it is needed, it's very important. They cause delays if you don't have it. Sometimes even denials. Evidence mapping, especially for O1 and L1s. You have to map your evidence to prove that you're eligible for that visa that you're applying to. And immigration history, this is one of the most important things that I tell to my clients, is that when you're applying for any type of visa, it doesn't matter what you're applying to, you have to show your immigrant history, right? Immigration history, and you have to show there is no gap. You're not unlawfully present in this country. Since you step into this country, you always had a status. That's what you need to show. So this is very important for applicants, and for both, for employers and for applicants. You have to have a common strategy. Why this type of visa? Why now? Why this structure? So this preparation reduces our fees. I hope this answers your question.
Definitely does. No, it definitely answers the question. Thank you so much, Ibrahim Caglar. So I think the final question from my side is, so based on recent adjudication trends, how is the USCIS signaling closer scrutiny in work visa cases? And what should applicants keep in mind when planning to file in 2026?
Okay, great question. First, immigration is a change. It's constantly changing, right? Immigration law constantly changing. So and what we see, which is a trend now, that USCIS signaling higher scrutiny in work visa cases, and in some type of work visa cases, such as H-1Bs, they have announced some significant policy changes that will affect the applications in the coming years. And my prediction that it will reduce significantly, but we don't know because There are a lot of lawsuits right now in federal courts. A lot of attorneys and applicants are challenging that, but we don't know. So, but to answer your question, what we are seeing is that more RFE questioning regarding to employer and employee relationship, specialty occupation, and managerial versus hands-on roles. Increase scrutiny of startups, remote work. This is one of the things that I see a lot, because this started in 2020, right? During pandemic, right? A lot of remote work. They were getting approvals, but now that I feel like that is changing, and USCIS is looking at the remote work with higher scrutiny. And also another area of higher scrutiny is, I think, self-sponsored or founder cases. Officers are relying heavily on business realism, not just the legal theory. They want to see, we want to see, for example, the financials of this and the employer-employee relationship. That's what we are seeing now. And I think what applicants should keep in mind for 2026 is that they expect maybe less. I don't want to be pessimistic, but I will be like advising to my clients that when you are planning or filing a petition for a work visa, you should expect that there will be higher scrutiny, and you should strategize to maybe take advantage of premium processing, right? Documentation must tell a coherent business or professional story, and you should be conservative and file your application it should be well structured. Credibility and consistency will matter more than ever. It's always, of course, it's always very important. But this year, I think USCIS will be. That's what they're signaling, and that's where they're saying that they will have higher scrutiny, of course. But I'm always optimistic. I know that immigrant workers in this country, they are very important to economy, to U.S. economy, and to world economy, and that therefore I feel like there will be always need for immigrants in this country.
Of course, makes sense. Thank you. Thank you so much, Ibrahim Caglar, and thank you so much for all of the valuable insight over there. I think just to everyone joining us live, work visa filings require thoughtful planning and a clear understanding of how eligibility is assessed. So, staying informed can help individuals and employees approach these decisions with greater clarity and confidence. And if this is your first time tuning in, welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration-related questions at no cost and engage directly with participating attorneys. And we are also proud to share that ImmigrationQuestion.com is BBB accredited and ISO certified, reflecting our commitment to transparency, accountability, community education, and security. So, Attorney Caglar, based on your experience, how do platforms like ImmigrationQuestion.com help immigrants and immigration attorneys like yourself?
I feel like they have great importance to immigrants in this country and also immigration attorneys. It gathers, it has a great importance in terms of gathering immigrants and immigration attorneys together to answer their questions, and also it is important to inform the public as well, I believe, So thank you for this.
Perfect. And thank you, Attorney Caglar. I mean, just thank you again for the insights. And we love to hear that both immigrants and immigration attorneys get value from this platform, right? So I think just before we move into our live Q&A, I think I have one final question for you. So Attorney Caglar, so for individuals who are still early in their careers or in immigration planning, like what steps can they take now to better position themselves for future work visa options?
I would say they should plan ahead. It's earlier the better, right? They should plan ahead, and if they have if they are planning to stay in this country or apply for work visa in this country, they should speak to an attorney to plan their future.
Makes sense. Okay, thank you, Attorney Caglar. So, I mean, I think, so just moving on to the Q&A, and I think if you've just joined us, we've been speaking to Attorney Ibrahim Caglar, Esquire, on which US work visa is right for you. So we'll now be moving into our live Q&A session, and this is your opportunity to ask questions directly to a licensed immigration attorney. So drop your questions in the chat or call us live at 516-703-3483, and we'll definitely try our best to take as many questions as possible. So I think we have our first question coming up, and the first question is from Bamishaya Ogini, and her question is, I heard a new rule ask employers to pay $100,000. Well, will that hurt my chances of getting a work visa?
Okay, so that 100K rule is for H-1Bs. Okay. So depending on what you want to apply, it might, because some employers are not, they're not thrilled to pay that, right? So I don't know, but depending on which type of work visa you want to apply, it might hurt your chances of getting a work visa. But there are other options. So you just talk to the employer that you want to apply, and also an attorney.
Makes sense.
I'm sure there is another option if H-1B is not right for you.
Thank you, Attorney Caglar. And the next question that we have here, it's coming from Katerina Dobre. And her question is, if my job does not need a university degree, can I still get an American work visa?
Great question. Yes, you can, depending on the visa, right? EB2, EB3. These are, so EB3s are usually heavily rely on experience, work experience, rather than a university degree. Like some H-1Bs too. So depending on the job position that you are offered to, you might be able to get an American work visa with your experience, not with your university degree.
Okay. Thank you, Attorney Caglar. The next question that we have here is from looks like M.O. Ruslav, and the question is, my employer is asking for proof of speciality. What papers does the USCIS want?
They want to see your degree. They want to see if you have any certificate related to your specialty. They want to see that. They want to see your work experience, and they want to see if you have any referrals and any kind of documentation to show that, to demonstrate that you are specialized employee in that area, in the field of, which area, it doesn't matter, but in that area that you're applying to, any kind of document that you can show, especially degrees, certificates, and job experience would be great. That's what USCIS wants to see.
Okay, thank you very much. The next question that we have here, and the next question is from Mara Chu. And her question is, can I apply for a work visa to stay and then change to a green card later?
That depends on the work visa. Yes, you can, generally speaking, but if let's say if you are on a non-immigrant work visa in this country, and then later you're planning to apply to a green card, then there might be some problems there. So therefore, I would say definitely speak to an immigration attorney to see which visa is right for you and plan ahead. Applying to a non-immigrant work visa and then later applying to changing that to an immigrant green card, right? That would might cause some problems, but generally speaking, it is possible, and there are a lot of people who done it, who is still doing it. Just be careful which type of visa you're applying to.
Great, thank you, Attorney Caglar. So the next question that we have here is from Adriana Rodriguez. And her question is, I'm already in the US on a student visa. Can I change to work visa without going home first?
Yes, depending on your program, you should be able to apply for an OPT. And then OPT is an work, it will give you a work authorization for 1 year, 2 years, depending on the program. Then later you might be able to apply for an H-1B. Yes, it is possible for you to stay in this country without going back home first and apply for work visa.
Thank you, Attorney Caglar. And just being mindful of time here, I think we have time for one last question, and this question is from John Paul. And it's the question is, does the country of origin matter for choosing a work visa?
Yes, it does. It does. For example, if you're applying for TN or E2 or E1, then country of origin matter, because some countries, some visas are country specific. For example, E2s, I was talking about E2 visas earlier. They are country specific visas. To be able to apply for an E2 or E1 or TN, you have to be a citizen of that country, a treaty country. It matters also if you're applying for EB1, EB2, EB3, because your priority date depends on your on country of origin. Your priority date, for example, if you're from India or if you're from China, it might be much later. Your priority date becomes current much later than if you're from some, let's say, Canada or some other country. That depends on the immigrants from that country. U.S. immigration system is very complex, and it's based on the country of origin, and that's how the system gives visas or visa quotas to people applying for work visas based on the country of origin. I hope it makes sense, but yes, it does. Just a short answer. Yes, it does. Yeah.
All right, Attorney Caglar, thank you so much. And I think that wraps up our Q&A section. So yeah, and I think just before we kind of wrap up, I have one sort of final tough question here for you. And it's just going back
I like
to
tough questions. Yeah.
So I think just going back to sort of recent news reports that indicate the federal government is challenging, right? So there's a Virginia law that allows reduced tuition rates for undocumented students. So how should immigrants and employers interpret developments like this? And what does it suggest about how immigration-related policies can shift at the state and federal levels?
Yes. So immigration is a federal issue. Immigration laws are federally, it's federally applicable in every state. However, states, they have a right to, like, depending on, of course, depending on issue depending on the federal circuit that they sit on. They might have different interpretation and application of that law. That's why employers and employees should look at which states they're in and which circuit they are bound to, right? They're subject to, and that's how they should interpret the law based on that to be able to get the right approach for them.
Okay. All right. So Tony Caglar, thank you so much for your time, and just thank you for sharing your perspective today. I think your explanations have really helped clarify a topic that can feel complex and I think overwhelming for lots. So just to everyone watching, just thank you for joining today's webinar. We really hope this session helps you better understand US work visa options and how to approach them thoughtfully. And you can always visit immigrationquestion.com to ask immigration-related questions and stay informed about upcoming discussions. If you'd like to revisit today's session or share it with others, there'll be a full replay available on Spotify. You just have to search for Borderless Talk by immigrationquestion.com. So just join us again on Friday for another live conversation covering key immigration updates and practical guidance. Attorney Caglar, thank you again for your time. We really appreciate it. Thank you for taking some time out of your day to join us in the live webinar today. And just thank you to everyone watching. So until next time, just stay informed and stay connected. Thank you, everyone.
Thank you for the opportunity.
Thank you, Attorney Caglar. Cheers, everybody. Bye-bye.